Hello, everyone, and welcome to the most recent edition of the NASJE podcast Spotlights. And today we have a spotlight on ADA accommodations and how we can better serve our courts in teaching them how to handle these. And we have a special guest, Michael Garbarino, who is an attorney and familiar with these on a personal level and in his practice. So I'll welcome you, Michael.
Thank you so much. It's a pleasure to be, and thank you for the opportunity to share my story.
Of course. If you would tell our members a little bit about yourself. I know you've been an attorney for quite a while, 27 years, I think you said. Let us know a little bit about your practice.
Right. Well, yeah, I've been a licensed attorney 27 years in Texas, and the first part of my practice was as a public servant. I worked as a government lawyer, mostly administrative law. It was wonderful, 15 years or so. I then went into the private sector, opened my own practice, and did various work, including real estate, but mostly civil disputes, and got interested in litigation, and so started doing some civil litigation courtroom work. All of that was going great. And then I had an interesting turn take with my health where I'm dealing with suppressed immunity. And this is relatively recent, within the last year or so. And on doctor recommendations, I was like, oh, wow, I really should be self-quarantining. Can I continue to do this work? And so I researched it. And the bottom line answer, I believe, under the law is that, an attorney can participate in a proceeding. And under the ADA, it is within the reasonable to accommodate that remotely for most proceedings, maybe for a complex jury trial or certain other types of things that may not be reasonable. But for most everything else, and especially given the events of COVID, right, and the after effects, right, the after effects, it's really changed our industries across the board. I remember the days where the in-person was what matters with regard to court procedure. For good reason. It indicates the importance that the participant applies to the matter. Yes. And so that's all fine. But what I'm finding is that there's been a real interesting variation in reaction from different judges on whether to grant the accommodation. And it is not, I don't find any correlation between, for example, the sophistication level of the court and its level of technology versus, whether they grant the accommodation and then how they hold the proceeding in light of their being a remote participant. I can give great praise to the judges of Texas. Texas is a cool state because we have these small claims courts that are administered, and the judges are local elected individuals. They're not required to be attorneys. Most are, but they're not required to be. And there's this fantastic program where they get to go to school to learn how to become a justice of the peace judge. Many of my cases are in those courts because those courts have jurisdiction for disputes up to $20,000. I think under Texas policy, that's a good thing. Texas is big on local control, local decision-making, local governance, and all of those are great things. So I do see a great variation in each judge's decision on how they want to handle a proceeding, but I can tell you that the quality is really up there.
As one of those people who helps put on those judge schools, we're really glad to hear that. And I'm sure the members of NASJE are as well, considering we invite many of them in to teach for us. So that's very exciting to hear the positive report. And that's actually how we met, right? You reached out kind of inquiring about the education and seeing if you could help. And so that's how we got connected for this. And I'm very excited to share this with my colleagues across the country because it is a topic that we've all been talking about in recent years, right? We now have access to even more ways to help people. And it's just become more commonplace for people to even admit that they need an accommodation, especially for some of these more invisible conditions. We don't know from looking at you that you might need an accommodation. And so that's sometimes a little more difficult for courts to navigate. And so you were telling me earlier kind of about the difference between some courts that do it great and some courts that maybe don't do it great. And like you said, it's technology is not the divide. It's just maybe experience or willingness to try. So why don't you give us a little bit more about how that works?
Sure, sure. I'll give some recent examples because I do now maintain an active full-time virtual law practice. I essentially self-quarantine in order to protect my health, but I still need to work and it's been an adjustment. But let me give an example of a court does not have Zoom, right? They haven't. And let me put in a quick aside. Sometimes this is budgetary, right? These are small local, so it's okay that nobody's expected to have all the latest and greatest technology. So let me begin with the courts that don't even have video or Zoom, but rather telephone. Can they comply with a remote appearance request as a reasonable accommodation of the ADA by allowing the participant to participate by telephone? The answer is absolutely yes. And it can be as simple as putting the individual on the speakerphone in open court,
Mm-hmm.
and all the other participants there. I have had that experience. And when the judges treat my participation the same as any other, I'm the speakerphone there in the courtroom. And
Mm-hmm.
otherwise, the proceeding is as it would otherwise be. I think that is just fantastic. It's such a simple solution, and it doesn't overthink the problem. Okay. Now I'll give a different example. I had recent experience just this week where I had some hearings, and the court's method of access is telephone. But for reasons not known to me, the routine is that all matters where there is a remote participant are put at the end of the docket. And so if the court has a lot of cases on the docket that day, that means that those that are making a request under the ADA to have access to that court and to participate in that court's proceedings are being put at the end of the line. Not intentionally. It may be for very legitimate administrative reasons
Mm-hmm.
in regard to how the court runs its operations. But it is food for thought, right? Is there a reason why those have to be at the end of the line? Or perhaps they should simply be in the same order as any other case under those same circumstances. One good example being an uncontested matter, and maybe defendant did not appear. Perhaps it's appropriate to not keep the remote participating attorney waiting for up to hours when there's not going to be a hearing. The default is going to be granted, that sort of thing. So now I don't complain. This is life. Life has its bear. You can't be hypersensitive. I'm just offering a sort of a best recommendation that if it's low tech, great, but just do what you would usually do is my best recommendation there, because these courts know what they're doing, with regard to the in-person. They handle it well.
Well, and I
Yeah.
think another solution could potentially be if you have multiple, of the online hearings to do them all on the same day or the same
Yes.
time, right? Like nobody has to sit on a computer or a phone from 9 a.m. until 11 just to get
That's
their
right.
case heard, right? It's a lot easier to do it, maybe set multiple docket times. I think that's what our courts do sometimes. And when I was
That's right.
practicing anyway, that was always helpful for me, even coming in person. So,
That's right. I think it shows great respect for people's time, while allowing the court to efficiently administer very often a large caseload. I have the benefit of practicing in the Houston metropolitan area.
mhm.
And so I get to participate in these very sophisticated courtrooms that have the latest and greatest, because Houston is a massive metropolitan area with all of that, as well as all of the rural area counties and the local JP courts, many of which are not like
Mhm.
or what I mentioned earlier. With regard to especially those courts that really have the Zoom proceedings down, and those they do it again. It's the same recommendation I made earlier. Just because there are some participants via Zoom, do what you would ordinarily do. Follow the same proceedings, same steps
Mhm.
that you would ordinarily follow, and you're going to be on solid ground. There are JP courts in Harris County that have entire days that are exactly what you just said.
Mm-hmm.
Zoom only. These include bench trials, right? These include actual, and what I love about it is that the court in advance, in its notice, tells all of the participants, hey, this is remote only. If you want in person, let us know, and we'll reset you to an in-person proceeding. But otherwise, we believe we can fairly administer these cases with everyone participating remotely. And, frankly, I think that's true. I mean, with many of these, for example, debt claim cases, it's about competing paperwork and getting the evidence in, in terms of how the case is actually administered. So, yeah.
Well, great insight there. And I realized as you were talking, I think we kind of jumped to the end here. We jumped to what do you do after you get the request, right? We didn't talk at all about the request. And I know you said you'd share a motion with me. So people could see kind of an example of what might be filed, especially to prepare those courts that maybe have never had this happen before, right? So they're not caught off guard. They know what to look for. So could you let us know a little bit more about, how you structure your motion and what you think is important to have in a request for an accommodation?
Yes. Well, first of all, you've got to get your request in a timely manner, to give the court a reasonable amount of time to process it. So that's the fundamental first thing, and that's a difference. If for an in-person proceeding, there's not any requirement per se that you do anything with the court ahead of time. Just be there on time. For this situation, no, I must make an advance request of the court explaining my circumstances and saying, I'd love to be there in person, but I'm so sorry. Instead, can I please participate remotely? And here's why. The way that I structure my motion is very simple. I cite to two primary authorities. First, I cite to the Texas Rules of Civil Procedure, which were amended last year by the Supreme Court to specifically authorize remote participation in court proceedings. I love how they did the amendment. It's for any participant in any court proceeding. It's worded in such a way that it's up to the judge, and it's within the judge's discretion to grant it or not. But it's also very clear that really the only bases to not grant it would be maybe you've got a jury trial. Maybe those need to always be in person. And if a participant has an objection with regard to the taking of sworn testimony, right? Those are laid out in the rule as sort of exceptions whereas I read the rule, the Supreme Court is saying to the judges of Texas, we concur. You have discretion to say no on where these are the particular concerns. But otherwise, we're kind of signaling to you, it's okay to say yes. That's how I read that rule. So I cite that rule, and then I explain what I just said about what I think it says. And then I cite to the ADA, the Americans with Disabilities Act, and to the requirement for, and this, by the way, is Title II of the ADA for public access to courtrooms. And courtrooms, are places of public accommodation that are subject to that provision of the law. And so this is about anyone getting access to that courtroom. I recently had one where the defendant, based on the information provided in the case, would also qualify under similar circumstances to me to remote participation. And in the particular instance, I didn't see where the defendant had requested it, but I make that observation because that's a case where, certainly we would not have objected even if the defendant wanted to give sworn testimony because of the defendant's circumstances. In the motion, I tried to balance why the accommodation is needed, giving sufficient information to the judge so they don't feel like they're being kept in the dark in any manner, with the privacy rights that I hold, the confidentiality rights that I hold with regard to my health status, my health conditions, my treatments, my doctors, all of that. We're all aware of that right to privacy. By the way, Texas is quite good with privacy because there's also even a common law right to privacy that's recognized Texas, it's quite strong. So the court has to take that into account. Oh, somebody's needing an accommodation. It's based on a condition they have. That condition is private to that person. So the processing of it should be done. What I do in mine is I refer to the condition. I describe generally why I need the accommodation. In my case, I don't mind it being public, that I'm dealing with a suppressed immunity, and so I self-quarantine. Beyond that, if the court wants verification, I'm willing to provide it. Case law is unclear on whether that's required to provide it, right? But if I'm willing, but I ask that, okay, please ask for that, in which case I will send it to you, and then please treat it as a sealed record. And then I just wrap up the request asking that it kindly be granted. So it's a less than two full page motion. And tries to get right to the point as well. I mean, you have to. I mean, these courts are busy. Get to the point. So.
Yeah, they want the point. That is true. On these busy dockets. Now, kind of as we shift, I talked to you a little bit about what our audience would be for this podcast, and it's folks like me who work in judicial education for a living, right? Some of us are lawyers, some of us are not. And what kind of tips would you have when we're educating about disability accommodations, or kind of anywhere in this access to justice realm, now that you've kind of navigated it professionally and done some research?
It's been an interesting experience because I never thought of myself as a disabled person, as a person eligible for protection under the ADA until these events happened to me. So I guess one observation I would make is it can happen to any of us at any time in our life journey. In fact, I get curious. I'm a nerdy lawyer, and so when something happens, I then start researching it, and it fascinates me. Most of us, most every one of us humans is going to be under some circumstance at some point in our life where the ADA is going to be implicated, and I hope that the circumstances are such that it's followed, right? So the person is treated fairly and equitably. I'm finding that is happening for me, and that's very encouraging, because the other thing is that the person in circumstances like I'm describing, here's the thing about the ADA. The history of it was, first, it was all about physical access to buildings, right? Mobility impaired people with other sensory deprivation disabilities being granted full participation, and the courts led the charge. I was so proud of the courts. I remember those days. Now it's about disabilities that are not so readily visible, but that are just as valid, that are just as real. And in order to grant that individual the fair, equal ability to participate, remote really needs to validly be considered. And so I guess what I'm saying is that courts need to be ready for this, because if they like it or not, it's coming. It's already here. And just like everything evolves, this is an evolving field, an evolving area. And yet complying with it is not hard. For those who are needing to teach court clerks, administrative staff, what to look for, what to consider, I really believe in the very old school, keep it simple, stupid method, and begin with the fundamentals. And I tried to cover those in this interview, that, just don't treat them differently. To the extent you can incorporate them seamlessly into your procedures, there you are. So.
Yeah, I think it's really been a great experience getting to hear your story, and just to kind of, it's a very not scary approach, right? It doesn't have to be this big thing. And I think that's something that sometimes the court staff maybe gets caught up in, right? They're very concerned about doing it the right way. And I think, like you said, just being compassionate with people and treating them like you would treat everyone else is really the key to all of these accommodations. So I really want to thank you for your time. I think this has been really valuable for our members. And I know you also had some resources to share. You, in your research, had found some courts that you thought are really doing a great job on their websites. So you want to talk about those a little bit?
Certainly. I mean, one of the things that prompted this, I mentioned earlier, is that the COVID pandemic, right? Well, what a lot of courts did, and is they were required under their local governments to adopt a
Mm-hmm.
COVID operating plan, right? What you'll find today with many, many courts throughout Texas is that they still have that COVID operating plan. Although the emergency is lifted, the plan is still in place. Under that plan, there is, and across the board, I see it in every one of them, how to address what they call the vulnerable population.
Mm-hmm.
And those are the folks that I would say meet the same criteria I'm describing, an invisible disability under the ADA that for good cause gives the person the right to participate remotely in that court proceeding.
Mm-hmm.
Uh, in those operating plans, it states you will prominently state on your website how to request such an accommodation, and then secondly, you will have a procedure to seamlessly grant them. I can send you examples, but I don't want to name particular. I don't want to call people out.
Yeah.
But I will tell you that most every court website I deal with has this, but not all of them. And it's so easy to add it. So I would recommend that. It's so easy to add it. And do understand, for those who may not otherwise understand, that the population of the disabled that I'm now a member of, we can be largely invisible in society. Why? Because what do I do all day, every day while I self quarantine? So I'm in my safe space, but I'm not out in the world. But how do I interact with the world? Oh my God, through technology, through the internet. So when your court website grants the information needed for those disabled folks, there you are. You've gone to just light years in terms of helping them to know what to do.
Well, I think that's all really good advice, and I really appreciate your time today. Are there any closing words you have for our folks?
None other than thank you for the educational programs you put together. I think they make a real difference in the world. And I wish you all a prosperous and happy 2024.
Thank you so much.